CitizenNewscaster.com.
Cases which come before the California Supreme Court should be of concern to all Californians. They affect the laws under which we live and our rights as citizens. Currently, the court is set to consider 3 such cases. Challenges to the constitutionality of Proposition 8, which some characterize as emblematic of the civil rights struggle of our time. To better understand the issues before the Supreme Court, CitizenNewscaster.com turned to 3 individuals, 2 constitutional scholars, and 1 former candidate for the United States Congress, with vastly different perspectives. Here is what they had to say.
I am an appellate attorney that practices in the Courts of Appeal in the California Supreme Court in various kinds of cases, civil and criminal. And I'm also a law professor at the Monterey College of Law, and in that capacity, along with several other members of the faculty, Amy Larson, Michael Stamp, Michelle Welsh are also lawyers and law professors. We serve as the supervising faculty of the Monterey College of Law Constitutional Law Center. And that's a program where law students can work with faculty in scholarly research and in preparation of motions and briefs in the various courts of appeal on important constitutional questions. 3 different sets of petitioners filed original petitions in the California Supreme Court, writs of mandate, asking the Supreme Court to decide the constitutional validity of the passage of Prop 8.
My name is Michelle Welsh, and I'm a local attorney here in Monterey County. I've been practicing for 30 years. I am the volunteer chair of the American Civil Liberties Union Monterey County Chapter Legal Committee. The American Civil Liberties Union of Northern California is representing some of the petitioners as their attorney, together with the National Center for Lesbian Rights and other organizations. So the ACLU is actually acting as attorneys for the petitioners.
My name is Jeff Taylor. My interest in the Proposition 8 Supreme Court cases going forward, I was a supporter of the proposition. I was encouraging, I was working on the front lines out with signs and banners and encouraging churches. I was working at organizing churches to get their membership to become registered to vote. The question today is, does a person of same sex, does a man and a man have a right to marriage? Do 2 women have a right to marriage? And I believe the answer is no. If that is the question, the answer is no.
There are 3 issues that the Supreme Court of California said it wanted to decide. So regardless of what the petitioners originally wanted the court to hear in their petitions, it was the California Supreme Court itself that said, we want to hear these 3 issues. And those 3 issues are, number 1, whether Proposition 8 was really a revision and not an amendment to the California Constitution, because a revision can't be done by initiative the way it was done. And number 2 is whether Proposition 8 violates the separation of powers, the balance of powers between the legislative, the judicial, and the executive branches. Then the 3rd issue is whether or not the marriages that already took place between the decision in the marriage cases, which became final in June, and the passing of Proposition 8 in November.
It gets confusing sometimes. I just encourage that we all go back to the very beginning. If we go back and look at the beginning and look at what was meant to happen in the beginning, that would help clarify a lot for us today.
The court has historically looked at whether or not amendments are valid and whether these initiatives are constitutional, often in the context of affecting rights of criminal defendants in the area of criminal procedure. And in fact, one of the cases that the petitioners rely upon, and we argue strenuously, perhaps controls or certainly informs the result here, is a case called Raven versus Dugmagian, where in that particular initiative, the people, through initiative, which is really a form of legislation. I think what's important to understand here is when an initiative is passed, it is like a statute that has been enacted by the legislature. It has the same force and effect. In Raven, what occurred was that there was a sort of a wholesale revision of all of the criminal procedure protections, Fourth, Fifth, and Sixth Amendment rights, as well as equal protection rights of criminal defendants. And one of the things the initiative said was that the California Supreme Court really could not apply California constitutional law. It must apply the law as established by the United States Supreme Court. It created a federal constitutional standard for interpreting the rights of accused citizens under California law. The California Supreme Court in that case found that that was a revision of the Constitution. That was not merely an amendment, but it affected a wholesale change on the sort of core operation of government.
Whenever there is an initiative enacted by the people, that is legislation. So as far as the three branches of government go, it is a legislative function. It's simply done by the people, though, instead of by the people's representatives in the legislature. But the Constitution itself requires that by initiative, the Constitution can be amended, but it can't be revised. It can only be revised, according to the California Constitution itself, by an action of 2/3 of the legislature or a constitutional convention, followed by a vote of the people. So the procedure that was used for Proposition 8, which was a simple initiative passed by a simple majority, a 52% majority of the people voting, the argument is it can't be done that way. Because it affects a revision of the California Constitution, not merely an amendment, it can't be done the way Proposition 8 was done, and therefore it's invalid.
Let's go back to 2000, when the state of California had an initiative, in a similar initiative process, but it was a initiative process that created a state law that had the same wording, that marriage relationship was a relationship between a man and a woman. Same exact wording. That was in 2008, and it passed by the vote of the people by 62% for. We as man, creating men's laws, should not go against God's laws and allow for people to give them the approval and the incentive to continue to go against God's laws.
Well, this is an interesting thing about Proposition 8 that many people don't seem to know, and that is that the language of Proposition 8 is identical, word for word, with the language of Proposition 22 that was struck down by the California Supreme Court as being unconstitutional. It's exactly the same language. They simply took it and put it into the Constitution as a new article in the Constitution, a new section, rather than a statute, as was invalidated in Proposition 22. It was in the Family Code, and it was declared unconstitutional because it violated both equal protection and fundamental rights. So it is exactly the same. It passed with far less support than Proposition 22 did in 2000, but still, that language has already been declared to violate the fundamental rights and equal protection of a suspect class.
The second thing the court did in the marriage cases was it reaffirmed the concept that marriage is a fundamental right, that is part of the personal liberty rights protected under the California Constitution. And those rights stem from the concepts of autonomy, personal choice, association, and due process.
A lot of the arguments that would say that this is a major revision or a minor revision go to the terminology of it has to do with rights, and I'm trying to think of the specific word that inalienable rights. And and we get the term or the phrase inalienable rights. We get that from the U.S. the Bill of Rights, written by Thomas Jefferson originally, and then it comes down, and many of the other states adopted that same phrase and terminology in establishing their Constitution. I don't believe that God, our Creator, said, okay, you're all equal. I don't think so, because He makes us all different. We're all individual, we're all unique, each one of us, and especially men and women. Men and women have specific nurturing capabilities. Women have the innate ability to be able to bear children. Men can help be a part of that, but they can't bear children. Men have an innate capability and muscle structure to go out and collect and tend and fend for the family. That is a partnered relationship that God designed. You can't become an equal citizen. You can't become an equal business partner. You can't become an equal spouse if you haven't grown to a point where you're similar.
Marriage was defined as a fundamental right by the California Supreme Court way back in 1948 in the case of Perez versus Sharp. And that was the case in which the California Supreme Court banned the prohibition on interracial marriage. And California was the first state in the country to do that. It wasn't until 1967 that the United States Supreme Court decided that marriage is a fundamental right. And that was in the case of Loving versus Virginia. And in that case, the Lovings, Mr. and Mrs. Loving, an interracial couple, were actually arrested and prosecuted for being married. And they were banned from the state as long as they remained married.
In order for Prop 8 to not defeat or affect other constitutional rights, long-standing, inalienable rights that have existed really as part of the Constitutional Convention in the 1840s, for example, whether or not Prop 8 can survive unless it is supported, like any other legislative act that affects constitutional rights, by a compelling state interest. The Attorney General's position is, the answer to that question is no. That Prop 8 is not supported by a compelling state or governmental interest or even a legitimate interest, as the Supreme Court decided in the marriage cases, which were the original cases that the Supreme Court decided in June, which did several things. One is it recognized an equal protection right for same-sex couples. In other words, a sexual orientation right that is protected by the Equal Protection Clause in California, the same way the California Equal Protection Clause recognizes gender as a protected classification, or what we call in constitutional law a suspect classification. And when one is part of a suspect classification, the court requires strict scrutiny of any regulation affecting that class.
What the court is looking at is when government classifies people into different categories. And certain categories have been called suspect classifications because they touch on something that is usually an immutable trait. It's usually something that a person cannot change. And oftentimes it is something that a person could change but has a fundamental right to choose. And in that sense, religion would be included, for example. People choose their religion, but they don't feel like they've made a choice. They feel like they have chosen the true and right way. But it's still a choice. And there are arguments that people choose sexual orientation, and there's scientific evidence that no, your sexual orientation is determined by birth and genetics. There are others who think it's a choice. It really doesn't matter. What this California Supreme Court has done is to declare sexual orientation classifications as a suspect classification. And whenever that is the case, whenever there is a suspect classification, the government needs to justify its actions. So whenever there's a government rule that treats one class differently from another class, and it's detrimental to do that, then the government has to justify it by a compelling state interest, and also would have to show that it is necessary to have this classification to meet that interest. Okay. So it's very, very high burden the government has to show.
These are men's laws. This isn't God's laws. These aren't laws from our Creator. These are laws that we keep just impounding on our Constitution and on our current legal situation. And these are laws that we use to protect people, to protect groups of people. And I want to go back to the contention that if we follow God's laws and we served one another properly and we respected each other properly, and to the extent that when we're in sin, we repent, and when we identify ourselves as being in sin and we repent that sin, because those sinful activities, there's a reason God doesn't want us involved in those sinful activities.
Telling courts it cannot in the future, it shall not in the future, interpret the Equal Protection Clause to create protections for this discrete group of individuals in our society. In other words, some have rights, some do not have rights. That directive to the court, this is essentially what this legislation through initiative does, materially alters the role, in my view, materially alters the role of judges to interpret the Constitution in California. And it may, as a result, violate the separation of powers doctrine.
The separation of powers requires that the branches of government be equal. And if the legislative power that was used in Proposition 8 through the initiative process can actually take away from judges the authority to decide questions of equal protection for people in California, then that has significantly removed part of the power of the court and usurped it by the legislature. And not the legislature made up of representatives, but the people acting as legislature. And so this is the way in which it operates as a revision instead of an amendment, because it takes away the power of the court as the final decider of whether or not an individual's equal protection rights or a couple's equal protection rights have been violated by denying them marriage.
We should look at these decisions, and we should look at this issue in the contents of our early creation, which is the creation of the Declaration of the Independence and the Constitutional Congress and our Constitution as a nation, and then our state constitution came from that, and it all goes back to our creators. But at some point, they changed their opinion, and they what I consider, they legislated, they changed the law of the land. They allowed same-sex marriages to take place based on some evidence that they saw or something in society, possibly.
This concept of judicial activism is always, it's somewhat troubling to me. What happens is when people or one group, in particular, sort of the conservative aspect or conservative segment of society, gets very upset when certain judges interpret the Constitution in a way that seems to offend their sense of how things ought to be, and so the judges then get labeled as activists, judicial activists, and this idea that judges are sort of making up constitutional law, and that the Constitution itself really ought to define the limits of what the law is, and if it's not in the Constitution, we ought not to create rights and protect disfavored minorities, in this particular case, gay and lesbian individuals that want to get married. And so all of a sudden, someone like Chief Justice Ron George, who has been a traditionally moderate to conservative Chief Justice, who has been measured and I think again moderate and conservative on much of the criminal law decided in his court, is now been labeled, and I think it's somewhat, surprising, if not, kind of laughingly, that he is now an activist justice because he authored this opinion. The same thing with Justice Werdiger, who, a very well-respected justice in the associate justice in the California Supreme Court, moderate, sometimes conservative in her, in her interpretation of the law, has now been labeled, activist. This is troubling. This is really spin.
The case that originally established the authority of the Supreme Court in, I think it was 1789, the case of Marbury versus Madison. Justice Marshall was the original activist judge who said it is emphatically the power and duty of the Supreme Court to say what the law is. Somebody has to be the end of the line, and that is our courts. So when there's differences of interpretation, when there are different points of view and different arguments about what is a fundamental right and what isn't, it is the authority of the court to make that decision. And that's one of the separation of powers issues that has arisen in Proposition 8. Who gets to make that decision? Is it the people through the initiative amendment process, or is it the California Supreme Court?
Now, when I refer to judicial legislation, is that these justices read more into the Constitution, just like my earlier conversation about separation of church and state. They back then in the 1960s, they read more into the Constitution than what was actually there. And they created this separation of church and state policy, which has just continued to grow and grow to the point that everybody assumes that church should have nothing to do with any religious thoughts or values or morals. Values and morals even of Christian faith should not even have a bearing on, man's decision-making process.
There are church-state issues involved here, and from both directions. In fact, I have tried to understand better the arguments on the other side, the proponents of Proposition 8, and they do believe, and I think sincerely, that the passage of initiatives like Proposition 8 is necessary for them to preserve their ability to exercise their religion. There are others, the opponents of Proposition 8, who feel that the passage of Proposition 8 has interfered with their church's ability to perform marriages for people that it's authorized to do. And so we have churches now prevented from performing marriages for same-sex couples in order to protect the religious freedom, as they see it, of those who think marriage should be between only a man and a woman. And this has great significance because we are supposed to have religious freedom for everyone. And that means everyone. And so if society adopts a particular religious view of something like marriage or any other aspect of civil life, then it does deprive another religious point of view or a non-religious point of view. And that is the problem with initiatives of this type.
We have many Muslims living here now that are citizens of the United States. We have Hindus that are here now living as citizens of the United States. We have Buddhists. We have many other faiths and religions. Why not? Why shouldn't their faiths and their doctrines and their religions be allowed to be utilized in the scrutiny of constitutional context? Maybe, I think, might be the question or the reference. And I would say, and this would be, a lot of people are going to say this is bias. I would say no. Because they weren't in place in creating our Declaration of Independence. They were not in place in creating our Constitution of the United States. So why would we want to take into consideration somebody else, some other faiths, or some other religious groups' doctrines, beliefs? Why would we want to take those into consideration? And if the suggestion, should we rewrite our Constitution at this point? Why would we want to do that?
Since we live in a constitutional democracy, and that's the beauty of our founders setting it up this way, we don't live in a pure democracy. So the will of the people is not simply tyrannical. It's not a tyranny of the people so that whatever the people vote on is what goes. The reason we have a constitutional democracy is for the very purpose of protecting fundamental rights. That's why the legislature, acting as an initiative process or as representatives, can't ever totally ban speech, can't ever totally ban marriage, can't ever totally take away from us our fundamental rights. And that's what the Constitution is for. The Constitution is intended to limit what the government can do with respect to people and people's individual rights. That's the whole idea in the Bill of Rights. There are many, many examples of ways in which minorities would be mistreated or treated differently or unequally if it were left to a majority of the people to decide. The whole essence of having rights that are protected, fundamental rights and the idea of equal protection, is that the voting process through majority vote can act, but cannot act to take away somebody's fundamental rights or to deny them equal protection, to be treated the same way as everybody else in society. And that is our basic value. Those are the basic values that our Constitution was founded upon.
The implication of this case, especially the question of whether or not through initiative or through an amendment of the California Constitution, other constitutional rights may be abrogated or may be altered or may be taken away, I think is far-reaching. I mean, in some ways, this case is not just about same-sex couples getting married. This case is about whether or not the Supreme Court can divine and interpret and create and affirm important constitutional protections, and then, through an initiative, have those constitutional rights taken away. For example, we have anti-miscegenation statutes which have been declared unconstitutional. In other words, blacks couldn't marry whites and so forth in the 60s. Could, by initiative, the majority vote in California decide that black men can't marry white women? Would that be constitutional? We may start looking at things like jobs. We could see perhaps initiatives that might suggest, like Proposition 6 back in the late 70s, that suggested, well, that didn't suggest it. It attempted to regulate gay individuals being public school teachers. So are we going to see the revision of, or the sort of the recurrence of the kind of regulations that suggest that maybe women ought not to be firefighters or police officers? Are we going to look at who can hold property in the state? Who would be qualified to be credible witnesses? I mean, if you look at some of the history, there was a time when Asians were not allowed to be witnesses in court trials and they couldn't own certain property. There were laws suggesting or attempting to regulate who one could sell real estate to, and restrictive covenants that prevented the sale of real property to African Americans in California, commerce, for example. Would there be a revitalization of this kind of pinpoint discrimination?
I mean, he bent down and he doodled in the sand a little bit. And as he doodled, he thought, and he probably prayed, and he recomposed himself, and he just said, "He of you that has no sin, cast the first stone."
Let it shine, let it shine, let it shine. Community, all over my community, I'm gonna let it shine. All over my community, I'm gonna let it shine.